I will welcome you in my 7th lecture relating to legal compliance for incorporating startup. And I was discussing with you regarding incorporation of partnership, LLP and cooperatives. And in this lecture, I will concentrate my talk relating to law relating to limited liability partnership, which is commonly known as LLP. Now, in the last lecture, I have talked with you the law relating to the partnership. So, that was a general form of partnership, or which you can name it as a general partnership. And I have told you that general partnership is a quite flexible structure for your startup, and you can really start that particular type of partnership at any point of time without much of preparation. What you need to do, you need to enter into a partnership agreement, which we generally call partnership deed, and simply we can start a business, and then later on you can go and register that particular partnership agreement. But when you are talking about the LLP, LLP is more a formal business form. And if you refer my previous lecture, then I have said that LLP governed by the Limited Liability Partnership Act. And the Limited Liability Partnership Act provide the provision relating to incorporation of this particular limited liability partnership. It provides the qualification for people who can be partners of this kind of a partnership. It provides the procedure which you need to follow for running of this particular partnership or managing of this particular partnership. It compliance requirement is more in terms of financial disclosure, in terms of the qualification of those people who are managing this partnership, and in terms of restructuring of this particular partnership. Now, in my previous lecture, whenever I was dealing with the partnership, I did not talk with you relating to the restructuring of the partnership, because traditionally there was no as such concept of restructuring of the partnership for a general partnership, because if the business fail, you pay to the creditors and you dissolve the firm. But in case of the LLP, there is a formal provision has been created for those stress LLPs or stress scenario, wherein the firm is need to be restructured or reconstituted. So, let me take you through this particular law which govern this LLP or limited liability partnership, and while I will do that, let me share with you that some of the provision of LLP are similar like partnership. At the same time, there is a some of the provision you will find quite resemble with the companies. So, I generally tell my student that the LLP is basically a sandwich between a partnership and a company, or something some type of organization which is in middle between these two type of company. Partnership is extremely flexible business form. At the same time, the company is a quite a formal business form. So, in case of the LLP, you have built up the flexibility within the formal business form. Now, you need to incorporate the partnership. Now, incorporating the partnership means there is a certain procedure which has been prescribed under the LLP Act, and whoever wanted to be a partner or promoter of the LLP, they need to comply that particular procedure. To some extent, I have indicated this in my previous lecture, but let me repeat that you might require to have an incorporation document, which I am going to discuss little more in my subsequent part of the lecture. You might need to get a partnership identification number. You might need to get a name for your partnership, and for that matter you need to follow certain procedure. So, it is a quite a formal approach in this particular sense. Second important thing is that in case of the LLP, which gives a lot of age in terms of a business protection of the partners from the business risks, is a limited liability of all the partners. Now, in the general partnership, what I told that all the partners are jointly and severally liable, but in case of the LLP, the liability of the partners are limited. That means, their liability extend up to their capital contribution. If they have agreed to contribute a X amount in the capital of the company, the liability of this particular partner ends there only. It do not extend further than whatever they have promised in the incorporation document that they are going to contribute in the capital of this particular partnership. Next one is the compliance requirement is comparatively less than other formal business form, but it is comparatively more from the flexible business form like partnership or proprietorship. So, in case of a LLP, your compliance is in terms of filing of annual report, which will include the financial report of that particular firm. You need to do kind of a disclosure which is required for change in a partnership. That means, with the admission of a new partner in the firm, but it is not as severe as it is required for the companies itself. But at the same time, please remember, you are not exempted from other laws compliance, which I have also talked with you in my previous lecture relating to the partnership, wherein I have said that you need to comply the tax law, you need to comply the environmental law, you need to comply all other sectoral law if there is a prescription to comply relating to that. Now, being a body corporate means the LLP is kind of a person in the eye of law. Now, this is a little technical sense, what is the meaning of person in the eye of law? Meaning of person means, like, as a natural person, as you have certain rights, like, you can hold a property in your own name, you can go and sue a person if your right has been infringed, because statute is giving the guarantee of your right, or somebody can come and sue because if you have done something which is infringe his right, either a civil right or a contractual right. This kind of attributes is provided in case of a limited liability partners, when that is the reason we called it a body corporate. And being a body corporate, once it also prescribe further that what should be the qualification for its partner. So, if somebody want to enter as a partner in this particular firm, he has to be a person who has who can enter into a contract. That means you should attain the age of majority. Now, ordinarily your age of majority is 18 years, but if you are admitted under the Guardian and Wards Act, then in that case your age of majority will be 21 years. So, you need to understand you are subject to subjected to which law. Then you need to be a sound person, I mean person with a sound mind. That means you should not have a kind of understanding problem. You should not be adjudicated insolvent. So, these are the few parameter which is prescribed by the law is who can enter into contract. So, the person who is going to be qualify as a partner, he should not suffer from all these difficulties. Then in that case he cannot be a partner of this particular firm. Then this particular body corporate prescribe the minimum number of the partners, and it says that the minimum number of a partner is 2, and in no point of time the firm can continue more than 6 months, where the partner is reduced in 1. So, you need to take the partner immediately if one of your partner is died or met with an accident, and he met with an accident and he is unable to work, or he is became a mentally insane, or he is developed some kind of a incapacity which the law prohibit to continue as a partner. Now, there is another new concept which has been introduced under this particular act, which is known as a designated partner. Now, designated partner is a person who is actually responsible for all legal compliances. So, as I said to you that the legal compliances in case of the LLP is little higher than that of a partnership, and whatever these organizational legal compliances relating to filing of annual return, making other type of disclosure which law prescribe, this designated partner will be responsible for that. So, to put it other way around, the law specifies that a particular person will be designated who is going to discharge the day to day life, day to day work of that particular partnership, and he is also legally responsible, which is something different, or this is an additional provision which you won't find in partnership. Now, let me take you to next issues, that you need to have you need to prepare an incorporation document in case of limited liability partnership. Now, when we are talking about the incorporation document is almost similar like a partnership deed, where you basically define the relationship between the parties, as we have discussed in the previous lecture. But in addition to that, you need to give something more information, Like in the incorporation document, you need to talk about the type of business this particular firm is going to carry forward, which is more similar like company, and which I call a first public disclosure about the nature of business which the firm want to carry forward. So, the incorporation document should be according to the form which has been prescribed, and you will find there is a many form which has been prescribed for the purpose of the incorporation, and I am going to deal with this thing in my next lecture. Then you need to state the name and name of the limited liability partnership, and there is a certain formality to do that. I will also deal with that in my next lecture. You need to state the purpose of the business, or you need to state the proposed business of a limited liability partnership. Now, when we are talking about the proposed business, that means you need to detail out that what are the business this firm can carry out. That means there is a kind of restriction relating to change of a business all of a sudden without follow the proper procedure. Herein you have a restriction in compared to a partnership firm. In case of a partnership firm, you do not have any kind of restriction relating to the change of your business. If the partners agreed, you can simply change that particular agreement and go ahead with that particular change of business. But herein there is some kind of a statutory restrictions are there, because you need to state or specify that what kind of a business you want to carry forward. Now, you need to specify the register office, which will be the main office of carry forward the business. You need to give the name and address of each person who are to be a partner after the incorporation. And I believe there is a specific provision has been created, like as I mentioned before, it is known as partnership identification number, and there is a procedure which you need to follow for applying this partnership identification number. Then you need to specify the name and the address of the person who will be designated partner, and for that matter you need to give other information which is concerning the proposed partnership as may be prescribed by the authority from time to time. Now, why I am telling the authorities? Maybe it is not only the the incorporating agency, but it might prescribe by some of your sectoral regulator that you need to disclose the additional information while you are incorporating the LLP, and in that case you need to do that. Now, the partners in the firm need to contribute, and what are the things can be contributed in the firm? That has been prescribed in the law itself, and you will find it says that you can bring a tangible, movable, immovable property, or other benefit to the limited liability partnership, including money, promissory note, other agreement to contribute the cash or the property or the contract of service to be performed or to be performed. Now, as I have told you before, that you can bring many things as a capital to that particular firm. One of the thing may be the technology or the innovation which you have done and on which you want to build up your startup. So, as a partner you can bring your innovation you can bring the technology, you can bring the know-how, and in that circumstances, if you are not able to pay any other capital that is sufficient for you to treat as your contribution in the partnership form itself. So, there is every possibility that you can bring different kind of interest, like herein it said that is a service contract. You are the person who is skilled in a particular profession. Then in that circumstances, you can only bring your service, which is very important for development of that particular organization, or maybe you are expert in handling with some kind of a technology. That itself can be a very good contribution in that particular firm. Now, let me take you to the next issue relating to the financial disclosure. Now, this is one of the additional requirement which the LL.P is required to do, and in this point the LL.P is more tedious from the point of compliance than it is in partnership. Now, financial disclosure include that the partnership is need to maintain the proper books of account as prescribed under the law. That means, what kind of capital you have, what kind of assets you have, what are the liability you have incurred, what are the loans you have taken, and is that particular loan created any charge on the assets of the company. All these things need to be detailed out. Then you need to talk about, you need to give this limited liability partnership within a period of 6 months from the end of each financial year. You need to prepare a statement which is called a solvency statement. That means that your liability are not such that you are eroded your net worth and you are unable to carry forward the business. Because in case of the company, you are not required to do this particular solvency, giving a solvency statement, but in case of the partnership, as because these accounting standard are not that severe, so they need to give kind of a solvency statement. And solvency means that you are in a you are in a sound financial condition. In case of the business, it might so happen that your all the capital has been laid out, and there is a lot of receivables you are supposed to get, but those are in process. So that does not mean that you are becoming insolvent. You are a going concern, so you are laying your capital and further you are gaining out of that particular capital. So, whatever the state of your financial condition, you need to disclose. Now, limited liability partnership shall need to audit the accounts accordance with the rule as it is prescribed. So, you need to follow kind of accounting standard. So, herein again your compliance relating to the accounting is higher than that of a partnership. Now, if you are failed to comply with the provision of these particular sections, then in that case you will be punishable. Every limited liability partnership need to file an annual return which is to be authenticated by the partners. And this is one of the very important compliance for a limited liability partnership in comparison to partnership. And and if limited liability partnership fail to comply this particular provision, then it prescribe a for fine for not doing this particular thing from 25,000 to 5 lakhs of rupees. Similarly, if there is a designated partners also will be responsible for this. So, annual report is basically a disclosure in a public domain, and whoever wanted to have a transaction with the limited liability partnership, they will be always look for this disclosure, annual disclosure in a very structured form. There is a lot of work has been done relating to how to structure the annual report and how best can provide the information in the annual report, so that whoever the information seeker, they can get this particular information in quick succession. Though this work was more related to the companies, but even the LLP's annual report also matter of importance with the passage of the time, because many of the informal sector organizations are now incorporating as a LLP. So, as the time will pass, the annual report significance of the annual report of the LLP will be increasing. Now, there is three other issues I want to talk with you very quickly. These are relating to the conversion of limited liability partnership, and you can convert the limited liability partnership later on into a private limited company or a public limited company. And in my previous lecture, I have advised to you that it is always good if you have a capital crunch, or if you do not have a manpower to do a lot of compliance, then you incorporate your business as a or startup as a limited liability partnership, and later on you can scale it up as a private limited company or a public limited company. Now, one thing I like to put in your attention, that in case of the limited liability partnership, they cannot access the market to raise the fund. So, limited liability partnership cannot issue the shares in the market and raise the fund. Even if they are interested to raise it as a SME, they need to go to the financial institutions, then they can raise the fund. So, these limited liability partnership cannot access the market. Next important thing is, there is a provision, adequate provision has been made relating to restructuring of limited liability partnership. Now, limited liability partnership can merge with another limited liability partnership. There can be a compromise, there can be arrangement in case of the limited liability partnership. Now, compromise, the moment we talk about the compromise, it is basically renegotiating the date of the limited liability partnership. So, if some kind of a date which is given to the limited liability partnership, and over the years, because of the losses, they have accumulated lot of debt, then in that circumstances the limited liability partnership can renegotiate their debt with the creditors, and they can take the time, or they can have other arrangement for restructuring the debt. Similarly, it can go for other kind of restructuring, and the adequate provision has been made relating to this particular type of restructuring. Now, limited liability partnership, as I have talked with you in previous lecture, that the partnership can be dissolved. Similarly, limited liability partnership can be wind up and dissolved. Now, when we are talking about the winding up, basically we are indicating about the process which need to follow. Please remember, in case of the limited liability partnership, it has come by the operation of the law. So, if you want to put an end to the limited liability partnership, or if you wanted to exit limited liability partnership, then in that case again you have to follow the process of law. And when you are talking about the dissolution, again it is a equitable distribution of the asset which the limited liability partnership has developed over the years through the business. So, there is a specific provision has been provided relating to that, and even you can have some kind of provision in the incorporation document itself, and so that you can use that particular procedure for the purpose of dissolution or the winding up, in addition to whatever has been prescribed under the Limited Liability Partnership Act itself. Thank you.